Justice Mandisa Maya officially commenced her duties as the Chief Justice of South Africa on the 1st of September 2024, and it follows the retirement of Chief Justice Raymond Zondo. She becomes the first woman to ever hold the highest judicial office in South Africa. Her ascension is celebrated as a significant victory for gender equality and the continued transformation of the nation's legal landscape. Let's talk about the expectations she has of herself, and as well as the issues that she has to tackle in her role. And Alison Tilley is a senior researcher at Judges Matter and joins me now, in fact, the head of Judges Matter. Alison, good morning. Thank you very much. Appreciate your time this morning. We know Justice Maya has broken a few glass ceilings in a time, and we've spoken about this theme quite often, actually. The first woman judge on the SCA, and this is a role that commenced in 2006. Then the first woman president of the same court, and now this one at the Concourt. She has said South Africa, very disappointingly, with our lofty constitution and all the fancy laws that ensure that equality and human dignity are achieved in our lifetime, lags far behind many countries, even in the continent, insofar as diversifying its judiciary is concerned, and it is worse when it comes to putting women in leadership positions. So we know this is something she's passionate about. How do you see the road ahead in her pursuing this goal?
Well, I think she's got a number of issues that she's already expressed herself on as being concerned about and interested in. And one of them is the governance in the judiciary, and it goes to a shortage of resources to some extent, but also the independence of the judiciary. What she's been talking about is something that we call a judiciary-led administration. And essentially what that means is that the judiciary want to take the reins and run the judiciary themselves. They don't want the Department of Justice or the Department of Public Works being involved in the management of the judiciary. And, you know, she's expressed herself on this in her interviews, and it's certainly something that she's going to be interested in going forward. It's not necessarily the crisis issue. The crisis issue that faces her is the number of judges and the lack of availability of judges, particularly in Gauteng. And so I would imagine that's probably going to be the first problem on her desk this morning. Yeah. Is what to do about that.
And I want to come back to that one, Alison, because it is important in the context of delivering justice. I want to go back to the transformation issue around women, and the context on that is important. In 1994, there were only 2 women on the bench, and now the Constitutional Court comprises 33% women. The SCA, 48% is made up of women, and the other superior courts, 40% of the judiciary at high court level. Why is it critical that there are women across our courts represented well enough across the country?
Well, that's a great question. And I think sometimes we answer it by simply referring to the Constitution, which says specifically that when you appoint judges, you have to do so in a way that you can end up with parity in relation to both race and gender. But I think there are other reasons as well, and one of them is this question of diversity and a diversity of life experience, and that's one of the things that particularly Constitutional Court judges have spoken about, that when you come to the bench, you come to it with everything that you are, your background, how you were brought up, what you were taught, and it's really important that in that pool of people there are people that represent everything that we are as a country, in order to make sure that justice is really done. And I think that that's also important, and so as well as being a constitutional imperative.
Yeah, I know that, you know, my questions to you are long, but I feel like the context is so important in, foundationing, so to speak, what I'm about to ask you. But the public has to be confident that this court is open to all, that it represents them, that it is legitimate. We've seen it historically take on presidents, famously holding former President Nelson Mandela to account for a matter in relation to arrangements around the first post-apartheid local government elections. We saw the former president go on TV and, recognize the court as the final arbiter of those questions and then comply with the order. Also ruled on the approach of President Thabo Mbeki's administration on the treatment of HIV/AIDS in mother-to-child transmission, and so on. And then, of course, there were rulings on applications by the EFF, for example, and the Democratic Alliance that the former President Jacob Zuma had failed to uphold the Constitution by flouting a directive from the Public Protector. And this is all about Nkandla and so on. So I want to talk about how this sets the scene, Alison, for the intersectional challenges that Justice Mandisa Maya faces in maintaining the court's independence. And independence was actually top of that laundry list that you just shared with us moments ago of issues that she needs to meet head on.
I think there are two different kinds of independence, and we definitely have the first. So independence of mind, judges handing down decisions without fear or favor. I think we've done very well there, and I think we're internationally recognized as having an independent judiciary. The second question, which I keep coming back to, is this question of institutional independence, and I think the thinking is that you need both. The court has certainly, whatever its institutional position, the Constitutional Court and I would argue the other courts have certainly shown that they are able to proceed even where they're making decisions about the executive and about the president, about parliament. If anything, they've really been drawn in to all of these different arenas and resolving conflicts where perhaps we really want those bodies to resolve those conflicts themselves. So, Parliament really shouldn't need to run to the court to sort out its problems. But I think even given the pressure that we put on the courts, that they've certainly been able to hand down decisions in such a way that we all do keep going to the courts, even if there are complaints about independence at times. It certainly hasn't hindered or prevented anybody from going to court and asking, for matters to be adjudicated.
This is an ecosystem issue, and it's so interesting in the way that you respond to that we can see exactly how dependent the one is on the other, and why each of these institutions have to be uniquely and independently supported and muscular so that they can do their jobs, as you say, without then creating this extra challenge as the court as the final arbiter or the last recourse in matters relating to the executive. So how do you think she's going to need to navigate that? I mean, what does she have within her purview to begin to see that starts to happen? I know it's clumsily put, possibly, Alison, but what I'm getting on is how do we reach a scenario where there is that muscular independence and the court can focus, I don't want to say on more important issues because all of these are, but on issues that don't involve arbitering in those or being an arbiter in those matters?
Well, I think it's an engagement between the judiciary and effectively the Department of Justice, because they're the ones that would introduce legislation that would do things like create a legislative foundation for the office of the Chief Justice. You would have, certainly in terms of budgets, again, the Department of Justice. So it really, I think that dialogue hasn't been there for quite some time. There've really not been substantive exchanges, in my view. And I think that's something that we would need to look forward to, particularly around these legislative issues. We know that we need legislation to expand the number of judges who deal with disciplinary issues. That's completely in the hands of the minister. So again, something that, is going to need that engagement between the Chief Justice, the judiciary, and then the executive and the Minister of Justice.
And some of the other issues, just in closing, the failure to fill vacancies in various courts across the country promptly, especially when the retirement dates of every justice is known from the moment of their appointment, is unfathomable and harmful. I think that's a comment that you guys, as Judges Matter, had made previously. It meant that for long periods there were several acting Constitutional Court justices. So are we expecting better hygiene, Alison, and action on matters like these?
Well, I think what I do know about the Chief Justice is that she takes these matters seriously. And I think, she's a good administrator, and it's something that is front of mind for her. And we know that from the various statements that she's given in her interviews. So I'm encouraged. I think it's a good day, not just because it's the first woman Chief Justice, the first Black woman Chief Justice, but also because I think it's a Chief Justice who brings a very particular intentionality around the way the judiciary is governed. So it's exciting times.
Yeah, she's the head of the judiciary, and they say heavy is the head that wears the crown. Thank you very much, Alison. We'll be watching developments in the Constitutional Court under her stewardship with keen, with keen concentration to see if some of these areas and challenges that Alison's also been sharing with us are issues where there will be a substantive shifting of the needle.